Okay, here's our consolidation lesson on the judiciary in the UK. Top left, you can see the specification, the key terms that you need to be aware of, but also the focus. And you can tell that there's a real interest, I think, in this area in terms of the composition of the court, what its role is, and the level of power that it has, how it impacts upon either the government or the legislature. And this is reflected in the questions that can be set, either 9 mark or the 25 mark questions, looking at the influence in the Supreme Court, looking at its role, looking at potential reforms, whether or not it has too much power for an unelected body. Okay, basics. So what we need to know is that the Supreme Court was created out of the Constitutional Reform Act of 2005 and came to pass in 2009. And what that meant was the Lords had previously been in the House of Lords, then became the Supreme Court, independent of the legislature. To get into the Supreme Court, there's a couple of things which are very different to the United States, one of which is you apply, you're not nominated by the president as it is in the United States, and secondly, you're appointed by an independent commission. They put forward the names to the Queen, and as a result of which, those people then become part of the Supreme Court. Technically, the Lord Chancellor can ask the Commission to think again, but that doesn't happen. Okay, and I think the other thing that's different to the United States is there actually is a restriction in two ways. One, in the sense that those who are applicants do have to have a legal background, and secondly, that they're actually restricted and must retire at the age of 70. They can't continue on until they die. Your knowledge organizer has all the key terms you need to be aware of, and these 15 terms, if you like, on the side are pretty much what you've got to be comfortable with. There's some key terms there in the peachy colour, judicial review, ultra vires, and declaration of incompatibility, which are important to understand and be familiar with when you're writing your essays. The involvement of Europe is also a relevant discussion in regards to the Supreme Court. In terms of looking at judicial independence, this is a particularly good article. We've looked at it before, but it's good to refresh your mind. It won't take you too long. And that will lead you into a discussion of whether or not we can argue that the Supreme Court in the UK is independent and impartial. If you're saying yes, there's clearly 4 points you can discuss. One, it's chosen by an independent appointments commission and therefore is beyond political influence. It probably doesn't have the same level of political bias as you might see in the partisan nature of the Senate committee hearings that exist in the United States. They're appointed to life, well, retire at 70, which means they're not held accountable by the electorate, which means they're independent of that political pressure. Their prior experience and expertise certainly implies that they have the ability to act independently. And you could argue that recent cases have shown that the Supreme Court is more than willing to be independent of executive pressure, as shown by the 2 cases of Article 50 and the leaving of Brexit and the prorogation of Parliament by Boris Johnson. To balance it up, there are arguments to say that there may be concerns in regards to the independence and impartiality of the court. One, the court itself. Looking at the court, you can see it's particularly white and not particularly well balanced in terms of gender. So you could argue that the lack of social diversity really shows it is still part of the ruling elite. Secondly, you could argue that they're actually quite limited in the way in which the principle of parliamentary sovereignty means they really continue to be subservient to the wishes of Parliament in terms of how they act. Finally, and this is quite a subjective point, is to say that judges being criticised for being too liberal, too willing to protect the rights of the individual against the concerns of national security, and that's been a point that's been put forward by ministers regularly. And that's what you would use, I would argue, to answer the question, explain and analyse 3 ways the Supreme Court can be considered independent. Putting the points on the yes side, but using the points on the no side as your analysis. Added to this, if you want to read this article, it's in the BBC website by Lady Hale, who's an ex-president, discussing the nature of the court and saying really it needs more greater social diversity in the recent future. This compares to the United States Supreme Court, as you can see in the top right corner there, which is clearly more gender balanced and more ethnically balanced than the one in the UK. Now, on to powers. We need to understand, I think, here the influence the Supreme Court has, how much power it really has in comparison to the parliamentary sovereignty that exists in the UK, and the limitations of the Supreme Court. The reality is that the court was created in 2009, but in fact the powers didn't really change from this point. So when we discuss the nature of the power, often it's a discussion about the nature of should it be reformed further, or how can it be compared to the US Supreme Court. Now in America, the US Supreme Court has significant power. It's the guardian of the Constitution. So it uses judicial review to judge both the constitutionality of congressional legislation and also executive actions. And this has been reflected more recently in the rulings against President Trump in regards to immigration. The UK Supreme Court, however, is much more limited. Ultimate power remains with the parliamentary sovereignty. And this means that Parliament will decide the scope of judicial power and what it defines as being legal. And that is a complete contrast to the US Supreme Court. There's no way the UK Supreme Court can say that something is unconstitutional if it's being passed by Parliament. So there are three key areas that have traditionally been the area of power for the Supreme Court in the UK. One, they can decide if new laws are compatible with the European Convention of Human Rights. That's after we incorporated it in 2000 from the Human Rights Act. They can decide if new laws are compatible with EU law. Now that comes from the fact that we joined the EU in 1973 and begs the question now with Brexit whether or not this role is going to be diminished or enhanced as we try to work out which regulations of the EU are still relevant in the UK today. And thirdly, they can decide if governing bodies are acting beyond their legal powers given to them by Parliament, and that's called acting in ultra vires, beyond their actual powers. That could be local authorities or it could be the government itself. Now, the point of having this list or table is to show you the different ways in which the Supreme Court can utilise acts in making judgments. So you have in 1972, 1998 and 2005 constitutional changes which have been important in the role of the Supreme Court. You also have other ways in which acts that have been passed have been challenged or been utilised. So, for example, the Crime Sentences Act or the Anti-Terrorism Act have been two ways in which they've tried to restrict the way the executive acts. There have been other ways, such as the Freedom of Information Act, where they've actually challenged the power of the monarchy. And if you look at 2006, it shows the role that the Supreme Court now has in really defining the relationship between central government and the devolved powers, as reflected in the discussions over Welsh devolution. There are three good articles which can support your preparation for this. The article about the Supreme Court and whether or not it's changed has some good examples in there. Andrew Desleur's article, which is quite old but still is useful in terms of outlining the different powers that the Supreme Court has. And a more recent article about judicial review in the UK and how it's been utilised. So, taking this on, how does it look in terms of 9-mark questions? Well, I would argue that you want to be using these points to answer a question about how parliamentary sovereignty influences a Supreme Court decision. First of all, you can say that the Supreme Court uses laws passed by Parliament with the process of judicial review. So, what it does is it uses examples of the Human Rights Act and the Freedom of Information Act to support how judicial review can occur. And the question is, how significant is this? That would be my analysis. Have the instances of using the Human Rights Act increased over time? Number of cases that the Supreme Court are looking at increased over time, because that would imply that parliamentary sovereignty is really significant in allowing the Supreme Court to act. Secondly, you can say the Supreme Court has actually been seen to protect parliamentary sovereignty from executive overreach recently in a couple of key examples. And it'd be good to explain how the Supreme Court has made sure it's protected parliamentary sovereignty over the issue of the ruling on Article 50 in May's administration and the prorogation of Parliament for Johnson. The question again is how significant this. I might actually take it from an angle of what was the reaction of the media, because the media were quite condemning of the Supreme Court in doing this, even though they were actually protecting parliamentary sovereignty. Third point is actually taking it from a slightly different angle to say the Supreme Court can be limited by parliamentary sovereignty. And what you want to say there is how the court can only rule acts incompatible, and executive actions can be actually made legal by the passing of additional legislation through Parliament, meaning that in some ways Supreme Court decisions can be quite temporary, showing the constitutional limitations of the court, certainly in contrast to those of the United States. The second 9-mark question linked to power, I guess, is to discuss the nature of limitations in the role of the Supreme Court. And there are three. You could argue that the Supreme Court can be limited by the undermining by politicians and the media. There are good examples of this, of how the court has been criticised for protecting individual rights at the perceived expense of national security, such as the deportation of asylum seekers, etc. And you could look again at the criticisms of the court itself in terms of its composition. If it's too liberal, for example, or perhaps not diverse enough, and how that criticism can actually impact upon the authority of the court. The second point would say that the Supreme Court lacks its public profile. Compared to the United States, it really isn't the significant body in the political system that it would probably like to be. And it's probably a reflection of the fact that it's subservient within the political system compared to the government or the parliament in the way in which it impacts upon people's lives. However, your analysis of this might be because it might make you say this limitation is becoming less of a factor over time as the profile of the court has increased and the number of cases that it's get involved in increases. Finally, and this is probably the most significant point, is the way in which the Supreme Court again can be limited by parliamentary sovereignty. The fact that its actions have got limitations, and as a result of which any laws being passed through Parliament really define the way in which the court can act. Okay, there are various points regarding to the nature of the court and also the powers of the court. Good luck.